The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Please be seated. All right, our first case is Smith v. Devine, and Mr. Coppola, you ready? Yes, both of you come up.
All right.
When you're ready.
Court ready? Sounds good. Good morning, Your Honor. Your Honor, and may it please the court. My name is Anthony Coppola. I'm the attorney for the appellants/defendants in this, the matter of Smith versus Devine. This case is about a $31 million default judgment, an evidentiary default, against defendants who showed up in court, tried to argue their case, and spent six figures doing so. They spent about $180,000 and didn't get their fair adversarial proceeding. There are two major issues with this outcome, and if you remember nothing else that I say today, remember these two things. One, the size of the judgment is huge. It's $31 million. It's unduly severe, and it's not tied to the amounts actually alleged or owed. Two, the prejudice to the plaintiff is essentially non-existent, and without that prejudice, the reason for default just isn't there. Now, a default, by its nature, is somewhat problematic. It has the ability to frustrate due process. In the case of defaults, as here, parties don't get their fair day in court. They don't get their adversarial proceeding. So defaults need to be used very carefully. Let's talk about the size. $31 million is a lot of money. It's at least $12 million more than the total debts of the bankruptcy estate as stated in the complaint.
Let me ask you this.
Of course.
Don't you all, before the bankruptcy court, there's this agreement between the parties in calculating how the bankruptcy court comes up with that number?
There is, but
So how does that? And I think the district court said the argument's not preserved as to the sum, because there's this agreement between the parties as to the number.
So I don't think we had an agreement. I was not the party I was not the attorney in the bankruptcy court, but I spoke to the bankruptcy attorney fairly extensively. The way the number came up is it's not the debts of the bankruptcy estate. There's sort of a range of what the debts were, from somewhere between 5 and 20 million. What happened here was they went after my clients for alleged transfers out of the bankruptcy estate and actually calculated a sum far higher than the transfers alleged. There was a $2.9 million notice from a QuickBooks file.
That this was a large judgment.
It is.
But there are also a large number of corporate entities.
There are.
I don't know, there's something like 54 different corporate entities.
There were 12.
So this was a rather extensive scheme, and one might remark that the size of the judgment reflects to some extent the number of corporate entities to which funds were transferred.
Sure.
And the other thing is that your unwillingness to respond to discovery requests gave the district judge, or the bankruptcy judge in this case, rather little to work with. And you say, oh, well, this isn't precise enough. But part of the lack of precision was brought about by the unwillingness of the Devine affiliates to give the district court any information.
That brings it to my point about prejudice, which I think is relevant, is exactly relevant here. My clients are accused of not producing documents. My clients produced approximately 3,000 documents through discovery. They answered about 86% of the interrogatories to the satisfaction of the bankruptcy court. There were 269 interrogatories. But the bigger issue of prejudice is that kind of gets to the prejudice against the plaintiff. And I don't think there is prejudice here because the plaintiff had all of the debtor's records, all of BK Racing's records, had every bank statement, had all the relevant documents, had about 1 million pages of documents. Now, I've heard it called 800,000. I've heard it called 1.2 million. Mr. Smith says that it's 11.4 gigabytes broken into 8,000-ish files. But they had a lot of documents. There was not a total lack there. And when you talk about breaking about a lot of entities, I represent 12 individuals and corporations. And the issue here is the court pierced the corporate veil. It actually sort of pierced the corporate veil on steroids.
The court actually say it's piercing the
It
corporate
didn't-
veil,
it did
or
not
just
say it was
use an
piercing.
analysis that suggested that they were looking at that?
You're absolutely right. It did an analysis that suggested they were looking at piercing the corporate veil. And what the court actually did was consider all of them as one, all of the corporate entities and the people. It ignored the separateness, the corporate separateness, because when you pierce the corporate veil, what happens is there is essentially an avenue from which liability may flow, say from a corporation to an individual. The corporate veil blocks that with limited liability. The piercing the corporate veil gets rid of that limited liability, but only opens the avenue if the avenue's there. What happened here is the avenue wasn't there. The court just mashed all of them together into a single block, sticking them all with the $31 million default judgment. Ron
What
Devine,
is the standard of review that this court has?
I think the standard of review is de novo review because there shouldn't have been evidentiary findings
What
based
authority
on
do you
default.
cite for the premise? Because some of the cases would suggest that it's an abuse of discretion standard.
That's understandable.
Where do you get the idea that this is de novo? I mean, I thought that default judgments are one of those things we've always reviewed under an abuse of discretion standard.
I think it's a matter of law. I think it should be, I'm not totally opposed to an abuse of discretion.
But you're saying because I disagree with it, the review should be de novo. You're saying because I disagree with the judgment below that our review should be de novo.
Well, I'm not necessarily saying that it's a revision of the judgment below. What I'm saying is the issue is it's about the test used below. And it's about whether the correct test was used and whether the correct law was applied. I think as I said, it's an overly large judgment. We have the case of GEMSEC, which specifically relates to the size of a judgment, calling a $10 million default judgment unduly severe.
Let me read something from the bankruptcy court notes, and this is compelling, particularly when we're looking at it as an abuse of discretion.
Of course.
standard. It says defendants have demonstrated, quote, a willful disregard for the bankruptcy laws, their duties as officers and directors of the debtor, their duties in discovery, and the rights of their creditors. They've repeatedly failed to make discovery, even after being ordered to do so by the bankruptcy court multiple times, and warned that they would face sanctions. That's pretty exhaustive review of the record in this matter, isn't it?
It is an exhaustive review of the record, but again, it doesn't. I'm of the opinion that the district court shouldn't have been reviewing the record as much as reviewing the law that was being used and that was being argued. So, like I said, that gets back to GEMSEC, which is saying that there's a certain size of default judgment that.
That's not exactly what GEMSEC says. GEMSEC says because that they were not able to show prejudice. It does not address the excessive amount. That's the finding in GEMSEC is based on the inability to show prejudice.
Yeah, there's a quote in my brief, and I don't have my brief up here, from GEMSEC that actually says that there was a finding of bad faith, but they were able to overlook the finding of bad faith because of the size of the judgment.
But you would agree that GEMSEC, the reason that case, the issue in that case was because the court did not cite prejudice in that case.
Right.
Okay.
No, I agree. It's not a perfect piece of precedent. No piece of precedent is, but it is what it is. See, the default really, I think the issue is it's non-evidentiary by its nature. I think the courts below erred in not making enough of a distinction between the evidentiary and the non-evidentiary. The bankruptcy court entered a 70-page order. It considered numerous evidentiary points, and it said there was a substantial evidentiary record. But at the same time that it says there's a substantial evidentiary record, it's defaulting my clients for not producing enough evidence. There is evidence there. And when you were talking a minute ago about the prejudice in GEMSEC, the behavior, I think the prejudice just isn't here because the plaintiffs had such a large body of documents.
In this case, though, to come up with the $31 million determination, it seems that the court was able to identify two criteria that they could use to come up with a figure and then use the ability to treble damage the amount based upon the willful, as the court viewed, the willful nature of your client's behavior in this case. So isn't there a basis for this $31 million determination?
I think there's a basis. I don't think it's a good one. My clients, for example, my individual clients, Ron Devine was accused only of about $20,000 in transfers. Brenda Devine was accused of taking a little under $60,000 in transfers. Those were the original accusations in the complaint. They ended up getting stuck with a $31 million judgment. This judgment is larger than the total debts of the bankruptcy estate. So what it would mean was...
Wouldn't it have been to your client's advantage to actually turn over the documents that were sought in discovery to provide, from your perspective, a more significant view as to what the damage determinations should be?
I don't think it would have been... I'm of the opinion that as much discovery as can be produced is good. I agree with that. My clients at least claim that they produced as much as they had. This again is a very large default, and what's being alleged essentially is they kept sloppy records. Sloppy records is not the same.
The difficulty is here, as I read the record, that what you did was virtually unprecedented. I mean, what you did was to try to grind the entire proceeding to a halt. Mm-hmm. And what struck me was that the district court exhibited extraordinary patience with your clients. And there were numerous warnings given which were disregarded. In many cases, there were no discovery responses at all. And not only did this district court show extraordinary patience, but when the bankruptcy court wrote an opinion, it was exhaustive, and it was very individualized, and it addressed each of the Devine affiliates individually. And given the way in which you sought to bring the proceedings to a standstill, and given the district court's patience, and given the thoroughness with which the district court, or the bankruptcy court actually announced its ultimate conclusion, how do we rule that an abuse of discretion?
So it's not as cut and dry as the bankruptcy court lays out, and I appreciate that it's a little difficult. My client, Ron Devine, started the case as a pro se claimant, which is part of the reason the discovery had issues in the beginning. As a pro se claimant, he's an entrepreneur. He's used to doing his own business, and he didn't really know what he was doing. He did a bad job with the discovery at the beginning. But doing a bad job is not the same as taking away somebody's fair day in court.
All right,
thank you.
Thank you, sir.
Appreciate it.
We got some rebuttal time. Mr. Houston.
May it please the court, Andrew Houston on behalf of Matthew W. Smith, who is the appellee and the plaintiff in the bankruptcy litigation below. Mr. Smith respectfully asked this court to affirm the United States District Court for the Western District of North Carolina order and opinion that was entered March 5th, 2024, which in turn affirmed 4 separate orders of the bankruptcy court. As a preliminary matter, panel, I addressed that the plaintiff submits there are dispositive or key decisional issues as it relates to each of those 4 orders that are addressed in the district court's order. I'd like to address 3 of those 4 orders very briefly at the beginning, and then spend the time for our conversation addressing the discovery sanction order. And so those 4 orders are as follows. The order holding Ronald Devine in civil contempt. I submit the district court should be summarily affirmed on this matter, as the appellants failed to address that matter before the district court. And given this issue was waived in district court, it of course did not abuse its discretion in affirming that order. The case that's cited is In re Wallace and Gale Company from the Fourth Circuit. The second order that I believe doesn't bear a lot of discussion is the order granting Mr. Smith's motion for protective order and denying a motion to compel for the same reasons, waiver. That is embodied in the district court's opinion also. And then as it relates to the judgment, the district court's order on this point should similarly be affirmed. The district court did not abuse its discretion by affirming the judgment where the Devine parties informed the bankruptcy court at a hearing on December 6th, 2022, that they agreed with our calculation of the damages, that the damages set forth in the complaint were for a sum certain, and they did not need a hearing to attempt to liquidate or contest the amount of that judgment. The case that's cited by the district court, they cited an unpublished case from this court called Williams versus Lynch. They also cited a case called Lynch versus Massini Holdings from the Second Circuit, which stands for the proposition, quote, the failure to raise an argument in bankruptcy court constitutes waiver even if the argument is subsequently raised in the district court, close quote. I don't plan to spend any more time talking about those orders unless you have any questions. I'd like to focus on what we call the discovery sanction order, which is the 70-page opinion from Judge Whitley in bankruptcy court.
And getting to that, the $31 million that seems to be the subject that we're discussing here is not specifically requested in the complaint. Do you agree with that?
I do not. And in fact, let me explain how that number was calculated.
That was going to be my next question. Walk us through that.
Yes. So the complaint, contrary to what was represented, the complaint sought to avoid and recover transfers totaling approximately $6.4 million that were paid to or for the benefit of the defendants. The defendants, of course, are Brenda Devine, Mr. Devine, 7 wholly owned companies and entities, and 3 family trusts. The claims that were asserted also included breach of fiduciary duty claims related to Mr. Devine and Mrs. Devine causing the debtor to incur $12 million, a company assuming its owner's debts. Those claims, the breach of fiduciary duty claims related to the $12 million, those are not trebled under North Carolina law. The other claims are, they're considered unfair and deceptive trade practices when parties engage in a pattern of concealment and secreting assets. And under North Carolina law, the Unfair and Deceptive Trade Practices Act, there is mandatory trebling of damages in that instance. So the math...
The suggestion is the $6,376,366.63 are those items which are trebled?
Yes, sir.
Okay.
Yes, so that figure is trebled. The roughly $12 million is not trebled. So that is what builds into that $31 million figure. And again, back to the record, the defendant appellant's counsel below, we had a hearing December 6th. They agreed. I mean, they told Judge Whitley in bankruptcy court that although they certainly disagreed with the result, they said they agreed that the amount was for a sum certain and that they agreed with our calculation, and they did not need a hearing on that matter. That is in the record. The transcripts are even in the record here.
Seems to me that
yes,
the appellants are objecting to any sanction at all. And that imposing a sanction by virtue of default judgment was just an abuse of discretion from the get-go.
They certainly say that, Your Honor. I believe that position ignores the very lengthy record, which includes the significant prejudice to Mr. Smith, and that's a question. Mr. Coppola said there was no prejudice. I beg to differ significantly on that point, and I'd like to talk a little bit about that. The claims that we brought in the complaint, as I mentioned, unfair trade practices claims, civil conspiracy claims, fraud claims, allegations of alter ego based on this Byzantine series and sequence of corporations and shell entities that were controlled by the Devines. The documents that were not produced were staggering. And I'd like to just rattle off a list of some of these documents just to consider. And I think I would ask the court to consider my remarks in light of your precedent in the Mutual Federal Savings and Loan case, as well as the May case. They're both cited in our brief, but I want to discuss those cases. It relates to these failures. The documents that the defendant, appellants, the divine parties failed to produce in response to discovery were staggering. Tax returns, bank account records, financial statements, accounting software in native format, loan documents and ledgers, corporate records showing the management and ownership of entities. They didn't produce any communications whatsoever related to the challenged transactions. There was non-disclosure of alleged loans that were made to the debtor. There were undisclosed bank accounts. Mr. Smith and I independently found 54 or 57 bank accounts that they failed to disclose in response to interrogatories. There were undisclosed entities. I believe, Judge Wilkinson, you are correct that there were 54 entities that weren't disclosed who Mr. Devine testified also had bank accounts. He just didn't know at what banks or where they were.
The only point I was trying
Yes.
to make is I've seldom seen such an extensive scheme with 54 shell entities or whatever that was constructed with the idea of bleeding the bankruptcy estate, and not only bleeding the bankruptcy estate, but bringing the court proceeding to a standstill. They wanted to do both things, to deplete the bankruptcy estate and also bring the court proceeding to a standstill so that the bankruptcy court could not inform itself of the full extent of what they were doing. But I think it's fair to call this unprecedented because I've never seen or have seldom seen such an extensive scheme that was designed to enrich the Divine affiliates at the expense of the estate, and also to bring to a screeching halt the wheels of justice when it tried to discover what in the world they were doing. It's a sad, sad story.
It is, Your Honor, and it has been going on since 2018. And in Judge Whitley's opinion, there are references made to this, I believe in the district court opinion as well. The case started that way. When the bankruptcy case itself was filed in February of 2018, it'll be 7 years this coming February, Mr. Devine, Mrs. Devine filed this case, the bankruptcy case. They ran, operated the debtor. Mr. Devine managed the operations, Mrs. Devine was the managing member, and they filed the case, and they refused to follow any norms from day one.
Your opponent colleague has suggested that the $31 million here is unduly severe. That's their basic position. And you've made reference to the fact that under North Carolina law, the damages can be trebled. Is that something that was obligatory on the court, or did the court have discretion as to whether it wanted to use that formula for determining damages?
With respect to trebling, it is mandatory under North Carolina's the Unfair and Deceptive Trade Practices Act. There's no discretion. It is mandatory that if there are damages, those damages are trebled.
I have about the documents. They in their brief said so they submitted over 900,000 pages, but I can't seem to find with the district court. There's no fact finding, I guess, from the bankruptcy court regarding the documents, because they're saying that they submitted over 900,000.
Yeah, so let me clarify what I believe they're saying and then explain to you why they're wrong and what actually is going on. They absolutely did not produce 900,000 pages, or there was a later filing in their reply brief that suggests there was 7.7 million pages of documents. That is just not the case. What they have referred to is what we in bankruptcy court call the quote-unquote trustee's file. It is the information that the trustee amasses as part of his investigation. Mr. Smith, as the record shows, He was appointed as the bankruptcy trustee, and he ran a NASCAR team, a professional sports team, for about 6 months after Judge Whitley removed the Devines from the management of the company. He then presided over the marketing and sale of the business, and then he has served as the trustee since. The information that they're talking about is the trustee's file. We provided the trustee's file to Mr. Devine and his counsel, and there were some other defendants that the same lawyers represented in the bankruptcy court. That's just information that Mr. Smith gathered while serving as trustee. What is in that file, I think, is pretty compelling. What is in it and what is not. First, I would start by saying there is literally nothing in the record that supports what they've said. There's no findings about those documents, the data. The reason there aren't is because the information contained has nothing to do with the discovery we've been talking about. What is in that file, pleadings from the bankruptcy case, audio files from the bankruptcy case, transcripts, documents and financials that Mr. Smith amassed when he was serving as the trustee. There are pictures of NASCARs, there's pictures of tires, there's pictures of engines. There is some limited information that he obtained. That's it. There's 8,000 files. There's not 90,000 pages of documents. From our standpoint, with the review, what is not in there are any of the documents that the defendants failed to produce. And I went through a partial list, and I would add to that list the defendants. It's an odd situation. You have a bankruptcy case. The people who ran the company, they maintain the emails for the company's key officers. Its CFO, its president, its bookkeepers, the assistant for the president, on another email server. All of that's gone. So we didn't have access to the CFO's emails, these people. And I think to make a technical argument here, the way that the court should consider that is there was certainly no reversible error. The defendant appellants can't point to some abstract amount of data and claim that the trial court or the district court committed error. And there is a reason they've never tried to tell you, or more specifically, point to the record to show what was actually in that file, is because it doesn't actually help them. They're just pointing to some superficial amount of data to try to make the point that we had enough documents without actually telling you what the documents are. And again, that's not in the record. So from our standpoint.
It matters from a broader lens. I think there are some cases in which it's important for an appellate court to back a district court up. This strikes me as one of those sorts of cases, given what the bankruptcy judge and the district judge were subjected to. They're just trying to gain control of their own proceedings in their own court. And an appellate court, I think, should be cognizant of that and back them up on it. And the other thing with respect to this has gone on and on and on. But I think it's important to send a signal that this sort of behavior is not going to be tolerated. Given what went on here, it seems to me that there is some value in saying this kind of thing is not going to be tolerated. Again, what struck me is the extraordinary patience that was shown in the face of extraordinary provocation.
And from our standpoint, we agree with that 100%. And I would be remiss if I didn't say it concerns me that there would be an opinion that would take the position of the divine parties in this case, which would go back and effectively countenance the way that they have treated Judge Whitley in bankruptcy court from day one, the way that they have withheld material information from creditors from day one. And you will see, I'm sure we've cited in our brief, that Mr. Devine, in the very first days of this case, was telling the debtor's bankruptcy lawyer that he did not want to provide information to fill out the bankruptcy schedules. And I know you guys don't deal with bankruptcy every day. I do. Bankruptcy schedules are a very important document that's filed in a bankruptcy case. It discloses assets and liabilities of the company, and it discloses all the transactions with insiders and related parties over a specific period of time. And the reason that Mr. Devine cited was that he didn't want to give the enemies any more ammo.
You say something that let the lawyers fight it out or something like that?
And that was the next point, which was said to Mr. Smith the day after he was appointed as the trustee. He told Mr. Smith that if Mr. Smith took the side of creditors, now this is a person who is appointed as a fiduciary for the benefit of creditors in a bankruptcy case to maximize the assets for creditors. Mr. Devine, the person who ran the company when all of these debts were incurred, told him, if you take the creditor's side, I will be your number one enemy and I will let the lawyers fight forever. That was 7 years ago, almost, that statement was made. In March of 2018, and here we are. That is how this case has proceeded over the last roughly 7 years, and it should stop. Your Honors, I am getting a little bit short on time, so I want to focus really on the issue of prejudice, and I would ask you to consider two cases that we've cited in our brief, and I would ask you to, I'm going to expand on this a little bit. They're the Mutual Federal Savings and Loan case, which is a 1989 case, and then there's also the May versus Phillips case. That's a case from last year, from 2023, and I see a lot of parallels between those two cases and this case. In our case, I believe it's actually a lot stronger, but those cases are as follows. Mutual Federal Savings and Loan. The plaintiff brought a complaint sounding in breach of contract, fraud, RICO, civil conspiracy, conversion. It had a very tortured posture, like our case, of discovery objections, motions, hearings, sanctions, et cetera. And the key issue there were the documents that were withheld. What were those documents? Bank records, the identity of lenders and related agreements, complete information about bank accounts, corporate financial books and records, just like our case. The district court in that case the district court entered an $8.9 million default judgment, which is a very large number in the 80s.
It's a very large number today.
Very large number today as well. And this court affirmed, saying as follows: the plaintiff suffered great prejudice as a result of the defendant's misconduct because plaintiff could not prove its case without the business and bank records withheld, which the trial judge described the materiality as essential. This court affirmed on those facts, just like in our case. The May versus Phillips case, which is a case decided last year, very similar. There were claims brought under the Telephone Consumer Protection Act and related statutes. There were claims of alter ego, transferring of assets, very similar tortured posture. What were the documents that the defendants withheld in that case? Tax and financial records, transaction-related documents, corporate records, emails. This court's termed the defendants engaged in sandbagging and producing documents after relevant deadlines. There were false representations made by the defendants, undisclosed high-dollar transactions, undisclosed entities. Sounds a lot like this case. Based on those failures, the district court in that case applied the Wilson factors, which is the test for determining whether default judgment is proper, entered a default judgment in the amount of approximately $828,000. On the issue of prejudice, this court said, appellant's failure to disclose this information not only deprived appellee of discoverable information necessary to prove her claim, but it also caused delays in the litigation and considerable expense to appellee because her counsel had to spend time researching and uncovering information appellants should have properly disclosed but chose to withhold. The court found prejudice. This court affirmed, based on the materiality of these documents, our case is just like those two cases, and in fact, in my opinion, substantially worse. This has been going on for 7 years, and it should stop. Thank you.
Mr. Copley, you've got some rebuttal time.
All right. I think I'll start off by talking about the entities. I know there was the discussion of 54, some undisclosed, 12 being total as my clients. Mr. Devine was in business for a lot of years. had a lot of companies. One of his companies, for example, he was a Burger King operator. Burger King said they were going to start making pizza, or at least this was the rumor. So he made a pizza LLC, had a bank account, started up, and then went nowhere, turned into nothing. And he did these over years. I want to talk a little bit about, let's see. I want to talk a little bit about my client, Ron Devine. I want to talk about the outcomes of this case, because I think the outcomes are important. I know there was some discussion about giving the trial court the leverage it needs to manage its courtroom. And I think that, in my opinion, trial courts need very broad latitude to manage the cases that come in front of them. This doesn't mean unlimited latitude. There's still checks on it. There needs to be a due process check on it. But I think
We're talking about basic principles of litigation, and I
Oh.
consider discovery basic principles of litigation. And there's at least a strong suggestion that that process is being undermined. Doesn't the court have the ability to try to remedy those situations with specific sanctions?
it does have the ability to remedy them with specific sanctions, but certain sanctions, especially, I think you need to balance the weight of the value and the ability of the court to remedy it versus the prejudice that the sanction places on the people. For example, say a court were to sanction somebody who was not a litigant in front of that court. I think that would be out of bounds because of due process. They need to actually be brought in front of that court. That would be too far. I think, anyway, in this case, I think what matters is you see the ultimate results of what happened from the court. Ron Devine is somebody who's been in business for 30 years. He had a lot of different companies. He employed 750 people at a time, thousands over the years. He was a rich man. He lost $47 million of his own money racing NASCAR. He put $29 million in cash into the team. He lost it all. The thing I like most about Ron is he's not bitter about his losses. He just wants to get back to building his business. But the issue is there's this $31 million judgment against him, and he doesn't have $31 million. Brenda doesn't have $31 million. None of these companies have $31 million. The $31 million is larger than the total debt of the bankruptcy estate.
Let's talk about it. And again, we are
Of course.
sensitive to the challenges that individuals have when they're involved in situations.
Yeah.
And we try to be fair and benevolent and all that. But the bottom line is that the sanction, the treble damage sanction, could have been avoided if your client had followed through on his obligation to meet the discovery requirements and guidelines. In other words, we might not have had $31 million, but for your client's actions.
I would say, my clients did produce discovery. I think they didn't produce it to Mr. Houston's pleasure. This is not the only case in this, out of this constellation of cases from this bankruptcy where discovery has been an issue. Mr. Houston has alleged that the discovery was inappropriate in several other cases. He's gone after Ron Devine's secretary, Nancy O'Hara. She has Alzheimer's. I was amazed by how much she produced, honestly, but he said it wasn't enough. Brought it before the same court, got the same result. I think...
How can you expect us to accept your view of the case and your view of the facts and all the rest when you fail to provide discovery? In other words, you would be infinitely better served if there had been a full record and you could have argued off the record instead of making lawyers' arguments without sufficient support in the record. But you've made an argument that we should accept this and accept that and your client's circumstances and all of this and what he's doing in business. But it all rings rather hollow when you won't provide the court the information which should furnish support for what you're telling us today.
Mm-hmm. I don't disagree with that. I was not the attorney in the trial court.
And I'm not blaming you
No, sir.
personally because you weren't the attorney at trial, and I'm sure you were not responsible for a lot of what went on. But on the other hand, you're representing the client on appeal, and so what went on at trial is your responsibility to defend.
Of course.
And it comes very near to being indefensible.
I understand that. Again, it's this balancing test. It's a question of the fair day in court versus the behaviors. And a part of it is we've kind of gotten into the weeds of the behaviors. I think this really it should have been decided on the merits. Now, I appreciate the discovery was lackluster.
How can it be decided on the merits when the information is on the
Mr.
merits
Houston
is
had quite a
not
bit of
being
information himself. He got it out of the. There are a number of secondary sources. I cite them in my brief that talk about default being inappropriate when there's some discovery. And mind you, they answered 86% of the interrogatories. It's not perfect, but it's a partial discovery. What I'm saying is, rather that it's a partial discovery, it's not a completely incomplete discovery.
All right, thank you.
Sure. All right. So in closing, I'd just like to say that, I'm out of time, sorry. I'll just, got my 50 seconds left. In closing, I'd just like to say, this isn't necessarily an easy case. It isn't necessarily a pretty case. I understand the arguments on the other side, but there's this question we have to ask ourselves of whether we want to look at defaults or whether we want to allow due process and have this adversarial proceeding. I think that the court should have tried to somehow have an adversarial proceeding based on what was there. Thank you.
All right, we will come down and greet counsel and then proceed into our next case.
Good morning, Your Honors. Thank you, and may it please the Court. My name is Elena Taylor, and I represent the petitioner, Ms. Blanca Cabrera Suchite. Remand is warranted in this matter for two primary reasons. First, this Court's recent precedent in Moons v. Garland requires remand as to the petitioner's motion to reopen for consideration of her application for cancellation of removal. The government cannot and does not dispute that the Board of Immigration Appeals applied the incorrect standard to Ms. Cabrera's motion to reopen as they applied matter of Coelho versus matter of LOG. The government simply states this does not matter. However, this is unavailing, as a single board member applied matter of LOG and would have remanded the case. The second primary reason that remand is merited, as the Board of Immigration Appeals abused its discretion by engaging in improper fact-finding when deciding Ms. Cabrera's motion to remand for consideration of her asylum application under a change in case law that happened during the processing of her appeal. As to the first issue, this Court recently decided in Moons v. Garland that the Board of Immigration Appeals abuses its discretion when they apply matter of Coelho versus matter of LOG to motions to reopen in removal proceedings as the generally applicable standard without explanation. In matter of LOG, the Board of Immigration Appeals explained that the generally applicable standard to apply to motions to reopen is whether the evidence provided demonstrates a reasonable likelihood of success on the merits, such that a merits hearing is worthwhile in the matter.
What is the exact problem that you're complaining about with respect to the BIA?
In the Board of Immigration Appeals majority decision, the Board of Immigration Appeals applied matter of quo, holding the petitioner to what they state is a heavy burden to establish that the outcome would have been different based on the evidence provided, rather than...
It seems I'm surprised that more attention wasn't devoted to the actual merits of your asylum claim or your cancellation of removal claim. It seems to me that the board didn't engage in, the board repeatedly cited to the IJ's record when it looked at the case. The board cited to the fact that Gersten, or whatever his name was, had found a new partner. As to whether they were a member of a particular social group was the reason for the persecution. The board cited to the new partner to say, no, this is not a particular social group. And then on the question of safety, safe relocation, the board cites to the petitioner living apart from Gerson, Rudy, and Merlin without incident. And then the question as to whether Guatemalan authorities were unable or unwilling to protect. Again, the board cited to the restraining order that the Guatemalan authorities had issued. So I don't understand. It seemed to me, looking at the record as a whole, that there was no question that the IJ was the fact finder here, and the question is in some way the IJ's fact findings were not supported by substantial evidence or were clearly erroneous. But to say that the board engaged in improper fact finding would be odd, because this is the very kind of review that we conduct all the time on the Court of Appeals.
Well, Your Honor, the immigration judge did note in his decision that the applicant, Ms. Cabrera, was in a relationship with her partner and that she suffered abuse as a result of this relationship. The immigration judge decision goes into these findings, but ultimately finds only as to nexus towards a particular social group presented at trial, which was family of the partner.
But isn't the thrust of your argument that the immigration judge got it wrong rather than that the board engaged in improper fact finding?
Your Honor, the thrust of the argument is that the applicant, the petitioner in this matter, Ms. Cabrera Suchite, was not given the opportunity to present the particular social group related to her partner, given a change in case law that happened on
Basically,
appeal.
what you're saying is because the case law changed, the analysis changed.
Yes, Your Honor. The case that changed was matter of AB, was an attorney general decision that stated blanketly that domestic violence-related claims generally do not qualify for asylum protection, and that the articulated particular social groups in these cases are defined circularly. Basically, they're defined by the harm, and therefore they're not cognizable. As that was the binding case law at the time, the petitioner did not present a domestic violence-related claim to the immigration judge.
Real quick, but your client's claim before the immigration judge was as to the brothers, not as to the partner. Is that correct?
Exactly, Your Honor.
And so I'm trying to understand your argument there. It was not before the immigration judge.
That is correct, Your Honor. So the immigration judge couldn't have engaged in findings of fact relating to this particular social group because it wasn't presented, given that it was foreclosed by binding case law at the time.
aren't you, in a sense, trying to have it both ways, essentially saying that, because as I understand the law, and this is not my area, you're a whole lot smarter than this than I am, but the way I understand it is that there's a sort of bifurcated analysis. The BIA cannot make its own factual determinations, but according to the Chavez case, the alien must establish a prima facie case, which then generates some degree of fact-finding. Would you agree with that?
Yes, Your Honor. The Board of Immigration Appeals is, of course, allowed to exercise judgment and make some sort of findings as to prima facie eligibility for relief.
And that's essentially requires them to sort of make some sort of factual analysis. I'm not going to say determinations, but factual analysis. Is that fair?
As to the
I was always taught in appellate arguments never to concede anything, but I'm going to ask you to concede something. If the law had not changed in the interim, would you still be in the same position today?
I think if the law had not changed in the interim, the petitioner would be in more trouble for not raising this argument below.
It's good to almost concede.
As to the findings of fact, though, the petitioner wasn't able to present these arguments to the immigration judge, and the normal course of behavior is for the Board of Immigration Appeals to allow the immigration judge to...
Just the problem I'm still having is I don't understand the view. I'm not sure I understand your view on the merits. If we look at it as an asylum case, the asylum statute sets forth certain particular grounds for persecution. One of those grounds would be that someone was a member of a particular social group. And so there's a question of whether the individual was a member of a particular social group when her ex-boyfriend had found a new partner. And then there's a question of, even if you find that there's a member of a particular social group, is there a nexus here? And a lot of the record seems to suggest that any sort of persecution was a result of a drunken binge or private domestic discord or what have you. But on both grounds, whether you're a member of a group and is there a nexus to the persecution, I don't understand the case on the merits. And with respect to the claim of cancellation of removal, I can understand the sympathetic aspect of that, to be sure, but I'm not sure how that squares up with Congress's requirement of an exceptional and unusual hardship due to the separation. So you bring up all these things about process, but I'm just not sure that what the ultimate case on the merits is, whether we're looking at an asylum claim or whether we're looking at a cancellation of removal claim. I'm not sure how you get there.
Your Honor, first, as to the asylum claim, the immigration judge in his decision noted that the petitioner suffered harm during her relationship. The analysis as to past persecution and membership as in a particular social group, of course, membership is a factual finding. If the petitioner was able to leave the relationship later but suffered harm during the relationship, suffered abuse during the relationship, that doesn't negate her membership at the time of the persecution. Rather, it goes to rebutting a well-founded fear of future persecution, as it could establish that she was able to leave, that there's a fundamental change in circumstance. But if she has established past persecution, it then becomes the government's burden to rebut her well-founded fear of future persecution. And as a result, the Board of Immigration Appeals engages in doing the government's job, basically, by rebutting her well-founded fear. However, in addition to that, for an asylum claim, there's also humanitarian asylum, which applies if the past harm was so severe or the petitioner would have suffered other serious harm upon return to the country, and that can be granted without regard to well-founded fear. So as a result, there needs to be the immigration judge finding as to her asylum claim because the Board of Immigration Appeals basically engages in rebutting her past persecution that the judge noted, and then not giving her the opportunity to present a potential humanitarian asylum claim, which could apply regardless of the well-founded fear. As to her motion to reopen for cancellation of removal does require a showing of exceptional and extremely unusual hardship, but at this stage, all that is required under a matter of LOG is a showing of a reasonable likelihood that a merits hearing is worthwhile to actually discuss the merits of the case. She isn't required to prove her merits case at this point. She only needs to demonstrate this reasonable likelihood that she could, at a merits hearing, establish an exceptional and extremely unusual hardship.
What exceptional, extreme hardship do you believe that she might suggest at a subsequent hearing?
Your Honor, I think that the documentation that she provided shows that her daughter is suffering from severe anxiety that requires her to be picked up from school, which is beyond the norm for, I believe, a 7-year-old child to be having panic attacks such that she needs to be picked up from school. This shows
that provides a basis for this exhaustive review of her newfound complaint.
Your Honor, I do believe that the evidence she provided shows a reasonable likelihood that it's worthwhile to explore this further on the merits.
Are you able to, I mean to cut you off, but I'm going to let you go through your analysis. Are you able to cite to any case that suggests that the circumstances of a familial relationship not applicable to the abuse that she's supposedly suffering is a basis for that individual remaining in this country?
I'm sorry, Your Honor.
In other words, what you're suggesting is that the daughter's circumstances provide a basis for your client to make her claim under the appropriate statute. Are you able to cite any cases that recognize that particular circumstance as a ability or prerequisite to allow a person to proceed?
Your Honor, in the Board of Immigration Appeals decisions on cancellation of removal, matter of Racinus, for example, the Board of Immigration Appeals analyzes these applications that are based on having a qualifying relative that would suffer exceptional and extremely unusual hardship. And in matter of Racinus, the Board of Immigration Appeals specifically stated that cancellation of removal is not so restrictive, such that only individuals that have family members with severe medical conditions would be eligible for this relief, that nobody else would be eligible for it. And so we would look to matter of Racinus, where the Board of Immigration Appeals also explained that it's a totality of the circumstances approach. And the petitioner in this matter provided not only evidence about her daughter's severe anxiety, she provided school records, she provided financial records.
So it's your position that their conclusion, the BIA engaged in improper fact-finding, they should have sent it back to the immigration judge on the merits to determine a cancellation of removal?
Yes, Your Honor. They should have sent this back to the immigration judge, and my time is about to expire, so I want to leave us with the fact that it's not just us saying this. A dissenting board member on the Board of Immigration Appeals also agrees with our position that the case should have been remanded for a hearing on both the cancellation of removal application and consideration of intervening case law. Thank you.
Zanfordino?
Good morning. May it please the court. I'm Richard Zanfordino. I'm here on behalf of the Attorney General. So I'm going to, fortunately, I have to use my cheaters a little bit here. The board neither engaged in fact-finding where it relied on facts determined by the immigration judge, nor did the board abuse its discretion where it accepted facts proffered to it as part of the motion to reopen. There's two different new trials that, essentially new trials of their hearings, but that were sought here. The first was a new trial saying, I want to do over on asylum. I've applied for asylum one way, I would like to apply for asylum a different way. And the board relied on the facts adduced by the trial level judge initially. The second motion was motion to reopen for cancellation. That came as part of, which is why we have two decisions in this case, saying, send this case back, I'm eligible for cancellation. The board accepted petitioner's facts, but found a lack of statutory eligibility. I want to touch first on the fact.
Wouldn't it have been more appropriate for the board to send it back on the merits, on the cancellation, for the IJ to consider, because the board does go into this, you know, is saying what's sufficient, what's not sufficient, and I believe in the record, there's affidavits from Cabrera and her partner.
Her current partner.
Carbara, yeah.
Sorry, the current partner, I was saying.
And a current partner,
Yes.
yes. Both saying that the child has been taken to a primary care doctor, is being referred to a psychologist, has upcoming appointments for treatment and diagnosis. Wouldn't that have been more appropriate before the IJ than the BIA in terms of fact-finding on the merits?
Well, Your Honor, they accepted the facts, first of all. But next of all, this is at a motion stage, and the Supreme Court in Abudu has said that motions are disfavored. So it's incumbent on the move-on to make certain things clear. And the Supreme Court has said there's basically three conditions where you can essentially prove out your case on a motion despite it being disfavored in the immigration context. The first is the motion regular? Has it properly been, does it comply with the regulations? Second, did you make out statutory eligibility? And third, discretion, which is where the LOG and Coelho fight obviously kicked in. But the board leads off this paragraph with very important points saying, literally, I think they start the sentence off with the word but, saying, but prima facie eligibility is still paramount. You still have to show statutory eligibility. Matter of LOG, and I'm going to talk.
Which I guess is my question, because they have these two affidavits, and so they're weighing the affidavits. They're saying that we showed a prima facie based on these two affidavits. It said that the child is having to be treated by a doctor. We're taking the child to a psychologist or psychiatrist, upcoming appointments, and so they're. But it just seems as if that may be more appropriate for the fact finder, the IJ, rather than the BIA.
Well, again, Your Honor, it might very well have been appropriate if you're an immigration court, and metaphorically, if the petitioner in the case was an applicant saying, "Here, Your Honor, I'm applying for cancellation of removal," and the immigration judge might have a bit of a skeptical eye, saying, "Well, you're aware of the so-called big three decisions." I'll get to those in just a second.
To follow up on Judge Benjamin's question, the LOG case has some very interesting language in it, and I'd like to read it and give you an opportunity to respond. It says, where an alien is seeking previously unavailable relief and has not had an opportunity, and I'm stressing the word opportunity, to present her application before the immigration judge, the board will look to whether there is sufficient evidence proffered to indicate a reasonable likelihood of success on the merits so as to make it worthwhile to develop the issues further at a full evidentiary hearing. In other words, it seems to suggest that the default is to go back and see if that evidentiary record can be developed and giving the individual an opportunity, not saying they're going to win, but an opportunity to develop that record.
Right, Your Honor, and that matter of LOG presumed that we've demonstrated statutory eligibility. It also presumed in that decision, it recognized that prima facie eligibility, there's no bright line rule about that every case is different. You have to look at the facts of every case, and in LOG they said, we think this is prima facie eligibility. The rub there is that was under suspension of deportation. And if I could just take a quick moment to try and explain, under suspension of deportation, that lasted from roughly 1962 to 1996. And this is the board's terminology. It required only extreme hardship. I don't mean to denigrate any of that, but that's what they said, was only extreme hardship. Congress stepped in 1996. And by the way, when you applied for suspension of deportation and you needed to show only extreme hardship, it was to me, the applicant. And then any concomitant hardship that would come up, you could build your case that way. Congress stepped in 1996 and said, no, the standard is now exceptional, extreme, and unusual hardship. And in matter of LOG, Your Honor, they actually differentiate because the old, boy, I'm getting very inside baseball here, but in the old suspension statute, there was extreme hardship, but there was a second level of hardship called exceptional and extremely unusual hardship. That was reserved for individuals with criminal history, security threats, certain fraud convictions. Then it would kick up, you'd have this heightened scrutiny, to steal a phrase.
If there's an incomplete record here, whose fault is that?
It's the duty at a motion stage for the move-on to prove out their case. The motions are still disfavored according to the Supreme Court.
Are you making the argument that the individual had the thing that had the opportunity to supply the facts that we are now saying should be that they're now asking should be remanded for?
They not only had the opportunity, Your Honor, once matter of LOG came out, little did that panel know. 3 months later, Congress would enact IRIRA. So as they're discussing the suspension standard, and at least twice in the LOG decision, they say, look, it's not like this is an exceptional, extreme, unusual hardship case. They differentiate, saying it's not one of these, it's just extreme hardship. 3 months later, Congress passes IRIRA that has that the standard that was formerly reserved for criminals, fraudsters, security threats is now de rigueur. It's now for everyone. That you have to show that it's beyond the norm. So what the board does is they seek to help individuals and say, all right, let's help you understand what exceptional, extreme, unusual hardship is. And they issue what is sometimes colloquially known among immigration practitioners as the big three. There's matter of Montreal, and these are in the red brief, by the way, of some of the facts, but there's matter of Montreal, comes out and says the facts are quite, these cases always, of course, stir your heart, but these numerous...
Where is this going with respect to the ultimate merits of either an asylum or a cancellation of removal claim?
Well, a move-on is aware of all the various big three, matter of JJG. They're aware these cases are out there. And so when they present a motion, they're trying to fit within those standard of those cases. They're trying to say, this is why my case fits in matter of Ursinus. Opposing counsel mentioned matter of Ursinus earlier. That's the one case where the board said this is a victory for the applicant. But for that case, that was a single mother of 6 children, 4 of whom were born in the United States. She had no family in Mexico. All of her family members who were immediate family members were in the United States lawfully, and the board in that case...
So you're saying that their strongest case is materially different
Yes, Your Honor.
From what is before us?
That's a more efficient way than I was going about it, but yeah.
Well, that deals with the cancellation of removal point.
Yes, Your Honor.
But what about the asylum point? And what about the nexus? What about, is there a protected group that can be alleged here? And is there a nexus from the protected group to the persecution?
No, Your Honor, and I would point out the petitioner did advance an asylum claim based on the partner originally. It's in the actual asylum application. In fact, I was just going to, if you note page, forgive me.
What are you arguing with respect to any asylum claim?
So first of all, she's waived any claim about the 2 brothers, essentially anything to do with asylum and the 2 brothers. They've given up any claim about those. When they filed the motion to remand to the board, they did it as a fait accompli. This is for a new trial, essentially. This is at the board level. They say AB has been taken away. Attorney General Sessions' decision in AB has now been eradicated by Attorney General Garland.
If we had to remand, there should be a reason for the remand. Ultimately, that it might result in some success. What is the reason for the remand here?
It would be futile to send back, which is what the board pointed out, relying on the facts that were laid out by the immigration judge. But I guess what I'm just trying to point out to Your Honor and to the panel is that when they filed the motion for the new hearing, they said, essentially, matter of AB has been erased. It falls back to ARCG, but the requirements for a motion to remand, which are essentially motion to reopen, are to spell out your case. Why do you win? Why is this worth sending back? And they simply said, AB has been erased. Send it back, please.
I think that isn't an argument that because AB, that she would have originally filed a claim, but she couldn't because of the matter of AB, and now that it's been vacated, this intervening case law, she should have an opportunity to file for asylum based on the former partner.
Right, Your Honor. If you notice page 374, that's actually page 374 of the record is their asylum application, where petitioner does say, by the way, my former partner persecuted me. They actually raised harm. In fact, her mother's affidavit was almost more about the former partner than the 2 brothers. there's a colloquy as well between, in other words, what we're saying is you had the opportunity to preserve because petitioner's counsel below felt very well to go to the trial judge and say, Your Honor, there's a new attorney general decision out.
Looking at the record as a whole, how does all this fit within the asylum statute?
Well, Your Honor, it's difficult because, first of all, they didn't allege a protected ground apart from ARCG in the original motion to reopen, which is what the board was left with. The board was left with nothing specific.
The question I was raising is, because I don't know where it's going on the merits, the question I was raising was, is there a protected ground? And secondly, is there a nexus? Is there a reason to believe that a remand would demonstrate the presence of a protected ground or the presence of a nexus? And with respect to cancellation of removal, is there any reason to believe that there's an exceptional and unusual hardship? Because that standard is phrased in the conjunctive and Congress made it hard to satisfy. So the question I have is, we can say, well, you should have an opportunity to do this, an opportunity to do that, and I understand that. But there has to be some reason for a remand, and there has to be some reason to think that this would eventuate in a meritorious asylum claim or in a meritorious cancellation of removal claim. And that's what I'm having trouble looking at. I'm having trouble envisioning the end game.
The board had
You see what I'm saying?
I am, Your Honor. The board had the same difficulty, and we have the same difficulty.
Pardon me, what did you just say?
The board had the same difficulty envisioning how they could have a meritorious claim under either application, because the board cited and said, you've incorporated ARCG without actually saying what the base of your asylum claim is. So then the board says the relationship no longer exists. You were able to move 20 minutes away and did not experience harm. We, the board, are aware of the panoply of cases, including Racinus, that says this is what it takes to make out a meritorious claim for cancellation of removal, not for...
Basically, what you're saying, that there's a two-part inquiry that must take place here, that your case is stronger on the cancellation of removal claim, but the asylum claim is probably the more attenuated basis for your argument because of the intervening law and the circumstances that may or may not be considered which would support an asylum claim.
Potentially, Your Honor. The rub there, though, is at pages 303 to 306, prior counsel below actually was in an extended colloquy with the trial level, with the immigration judge, forgive me, about an attorney general's decision. It's not matter of AB, though. The immigration judge never cited matter of AB. So when they came back to the board and said, because of AB, you must remand this case, but the immigration judge never employed it. The decision they were talking about during that colloquy was a different attorney general's decision called matter of LEA, which has to do with the definition of a family. And so the lawyer in that case...
The bottom line is that in these circumstances, we're put at a disadvantage because attorney general's positions and opinions change over time. Different attorney generals come in, different standards of review, and we have to sort out what the standard of review is at this particular time.
Well, in that case, yes, although at least in that case, petitioner's counsel in that case felt well enough to preserve and say, in fact, the trial level, the immigration judge said, what do I do about this? I've got the Fourth Circuit's Cruz versus Sessions case that's here. You're saying that we have a matter of LEA. Matter of LEA, by the way, came out one of the last couple days of July. This hearing's held like September 3rd, and they're referring to the Attorney General's decision that came out a couple weeks earlier. No one actually ever says LEA. No one definitely says that matter of AB during the entirety of the process. But they're laying out how do we build this case. In fact, the point of the colloquy was even the immigration judge was discussing with the parties, saying, metaphorically pointing, saying, well, DHS, you say there's no particular social group. Applicant, you say there is a social group. That was with an eye towards, does this case get submitted essentially on the merits without testimony? And that was when the DHS brought up and said, well, at page 689, the applicant said she had no fear of return to Guatemala, so maybe there may be a credibility issue here, Your Honor. We'd like to hear the whole case out. And so they went ahead and did. So for petitioner to come and say she was precluded when she had the opportunity to raise and say, I have a problem with this case, we'd like to preserve our opinion, we know as much as attorney generals change their decisions, some circuit courts disagree with attorney generals and they say, we think it ought to be this. So the advocate.
From a pragmatic standpoint, again, we often don't deal with pragmatism when we're making determinations, but from a pragmatic standpoint, what is lost by allowing this record to be developed on remand?
Your Honor, the motions, as the Supreme Court has pointed out, are disfavored. You have to actually build up a case. And the motion to remand in this case, which we do commend the panel to re-review at page 213 and 216.
But the government didn't oppose the motion to remand, right?
For the motion,
For the BIA, they did not oppose the motion to remand.
they did not file an opposition, Your Honor. But as petitioner has cited, two issues on that. They've cited the policy, they're going to sound the same acronyms, but policy memo and practice manual. So I'm going to refer to PMs, but they cite them incompletely, however. The policy memorandum was one of these matters that the immigration agency itself put out this policy memorandum that, for lack of a better phrase, essentially says work smarter, not harder. But the petitioners have left out the reserving language at the end of that memorandum that says nothing in this PM, policy memorandum, not practice manual, is intended to replace the application of case law, regulations to individual cases, or the individual judgment of individual judges and appellate judges. With the practice manual, the board likewise points out in their practice manual that was not cited by petitioner that even if something comes in within an opposition, that the board can still deny a motion. For the same reason, for instance, that circuit courts, or essentially advocates, don't bind tribunals. So if two advocates come in and say, we have an unopposed motion to waive oral argument, and the court may wish to hold oral argument anyway, it's going to hold oral argument. The two advocates may come in and say, well, this is an unopposed motion to remand. Some circuit courts will deny those and say, we're still going to consider the case because advocates don't bind the parties. And the board's practice manual points out that they have the power to do that even with an unopposed motion. For petitioners to rely on the policy memorandum, especially with the language at the end that says that it's not intended to substitute for the individual judgment of judges, including appellate court judges, on individual cases and apply regulations, apply facts to regulations. So, yes, of course, in certain cases, it may be a matter of saying, well, the two parties aren't fighting over something. Off we go, we'll just let it happen. But if the two parties have come in and the board recognizes and says, there's a fundamental flaw here. There's a fundamental flaw. For instance, statutory eligibility has not been asserted. We know about matter of Montreal. We know about matter of Vandazola, what we reversed.
And I think I interrupted you answering Judge Austin's question about what's the harm in sending it back to the IJ for the IJ to look at the intervening case law in this case.
So the Supreme Court has pointed out how disfavored these cases are because they extend delays. When that policy memorandum I referred to came out, the backlog was like 1 point something million. It's now 3.7 million of cases. So the government has an interest in having cases come to a close, especially where an advocate below had the opportunity and used the opportunity to preserve other arguments. In the case, the applicant actually cited her abuse by her former partner. So did her mother's affidavit. I see my time is up.
One more quick. But as to the cancellation of removal, she didn't have the opportunity to preserve that argument below.
Right, Your Honor, except that's where the board stepped in and said, as a matter of statutory eligibility, which is a legal question, the board referred to, and I want to point out matter of JJG in their decision. Matter of JJG cites what I was referring to earlier as the big three. I didn't get to really explain all three, but matter of JJG cites the original big three. That was a response to, matter of JJG was created because after 20 years of only having one case where an applicant won, applicants were all trying to fit themselves into the Racinus category, where the applicant won, and matter of JJG came out as a response to that and saying, if you're going to allege illnesses, infirmities, problems, you need to, as my teenager would say, bring the receipts. You need to lay it out. And in one of the cases for JJG, that published case was anxiety.
But it doesn't say that you have to have, in that case it did, but it doesn't say you have to show hardship, that you have to have an actual diagnosis, does it?
I'm sorry, I'm
Does it say you have to have an act? Because that's what the BIA, they said, well, she doesn't have a diagnosis. The child doesn't have any diagnosis, even though they had these affidavits that the child is undergoing all of this. The BIA, I think it's on JA4, they said that she does not have any, present any evidence specific to her daughter with regard to negative impacts. And then they go on and say because she doesn't have a diagnosis.
So a matter of JJG does require certain diagnoses because what they're trying to do is prevent, for instance, Dr. Google. So a parent stepping in saying, oh, my child has this, this, and this, but that's the parent saying it. They're relying on professionals to step in and say this is substantiating because people had been spending 20 plus years trying to fit into that particular bucket. I apologize to the court. I want to be responsive. I realize for the time. With that, we respectfully request the court would deny both petitions for review.
Thank you. Ms. Taylor, you have some rebuttal time.
Thank you again, Your Honors, and may it please the court. I want to start as to the petitioner's motion to remand for her asylum claim. First, for the first time at oral argument, the government faults her and states that she had this opportunity to raise it below and in her asylum application. It's clear that in the hearing, this wasn't considered by the court. And the agency is bound by the decision of the Board of Immigration Appeals, which doesn't fault her for failing to raise this previously. The Board of Immigration Appeals simply goes to the merits of the case. Now, as to the merits of her asylum claim, which I understand is a particular concern for the court, the prongs for an asylum claim require a finding of either past persecution or well-founded fear of future persecution on account of a particular social group. This requires that harm to rise to the level of persecution and that it's on account of a protected ground, here a particular social group. Well, she's established a cognizable particular social group under the Board of Immigration Appeals' own precedent in matter of ARCG, which the Attorney General reinstated in AB 3 as good law. So therefore, she has a cognizable particular social group under the law. In addition, the immigration judge found that she suffered harm due to this relationship, that it was from her partner. There is no clear finding as to whether that harm rises to the level of persecution, and the immigration judge didn't make findings as to whether or not the partner was motivated by that particular social group. But the fact is that the judge did find she experienced harm in the relationship, and these are factual findings that the immigration judge should be allowed to make in the first instance. As to, in addition, for an asylum claim, you need to demonstrate that the government of your home country is unable and unwilling to protect you. And the dissent in the Board of Immigration Appeals recognizes that the immigration judge did not make findings of fact on inability or unwillingness to protect the applicant. The immigration judge goes through the court order of protection against the brothers in the context of her Convention Against Torture claim, finding that there was no acquiescence, which is a higher burden to establish than government inability and unwillingness to protect. And the dissent recognized that the immigration judge didn't make these findings in the first instance and should be afforded that opportunity. And finally, ability to relocate, again, is something that the immigration judge did not make explicit findings of fact. He solely relied on nexus to the protected ground of the family of the partner due to the abuse from the brothers. Moving on towards the motion to reopen, the government repeatedly states that motions to reopen are disfavored, but this court has recognized that they're an important procedural protection in cases. This court has mentioned that in Moons, that these are important. So while they might be disfavored, they're still an important protection in immigration proceedings. Further, again, as to this claim for cancellation of removal, the immigration judge should be afforded the opportunity to analyze whether or not she merits that she's established exceptional and extremely unusual hardship. At the time of the filing of the motion to reopen, not only did she allege the anxiety to her daughter, she also noted that at the time she was pregnant with another U.S. citizen, the government faults her for the fact that the board has granted in cases where there are more qualifying relatives that maybe have higher level of hardship. However, In this case here, she has established a prima facie showing that her daughter would suffer exceptional and extremely unusual hardship because she's established that the daughter would suffer some sort of hardship beyond the norm. It's not normal for a 7-year-old to have significant anxiety such that she gets picked up from school because she has panic attacks. And this predisposition to anxiety would be further exacerbated by her mother leaving the country. Further, in matter of LOG, which is directly applicable here, because it's a new application for relief that was not previously able to be presented. In matter of LOG, as the government notes, that case concerned suspension of deportation, which basically is what cancellation of removal is today. It's basically...
Isn't the goal of all of these proceedings to have some degree of finality? In other words, we can't have individuals just coming up with new claims once they are denied. There has to be a natural end to all process, doesn't there?
Yes, Your Honor. But there's a 90-day limit to file motions to reopen that is required by regulations, and the petitioner abided by that limit. She filed her motion to reopen within actually 30 days. And with that, my time has expired. Thank you, Your Honors.
Thank you. We'll come down and greet counsel and proceed directly into our last case. Thank you very much. Appreciate your work. All right, Mr. Frederick, we'd be pleased to hear from you, sir.
Thank you, Judge Wilkinson, and may it please the court. I'm David Frederick for Gen Bio Pro. The issue in this case is whether West Virginia can interfere with a balance between access and safety Congress entrusted to the FDA for mifepristone. The answer is no. In 2007, when Congress enacted the FDAAA, it knew mifepristone was on a list of 16 drugs that had been approved with special post-marketing restrictions by the FDA under Subpart H. The 2000...
Let me just get it straight. You're bringing a preemption challenge. You're not bringing a silent commerce clause challenge or anything.
That's right. The issue solely is preemption.
The issue before us is strictly focused on preemption.
That's correct.
Okay.
And the argument here is that in 2007, when Congress enacted this act, it was the first time Congress had entrusted the FDA with post-marketing restrictions and regulations for surveillance and other special uses of the drug under highly specialized conditions. And what Congress did in 355-1F, which is set forth in the addendum to our brief starting at page 12, is a series of factors the FDA was required to balance in ensuring access to the drugs that were on this list while preserving effects that would have effects on the healthcare delivery system, on rural areas and other special needs patients. And that balancing is what West Virginia is seeking to interfere with here. Because what West Virginia says is that mifepristone can be taken only if there's a medical emergency or there's a non-viable embryo. The FDA, however, did not make the balance on that particular set of features. What the FDA said was that if the doctors, the patients, the pharmacies, the provider fulfilled certification requirements, a woman could take mifepristone within the 10-week period that it had been authorized and approved for use.
Are you suggesting that any time the FDA is dealing with a high-risk drug and regulates by virtue of REMS, that is automatically preemptive?
I think there are two.
But that's a very broad concept, isn't it?
Well, let me pack it for you this way, Judge Wilkinson. Under our field preemption theory, those drugs that are subject to special safe use elements, there are approximately 70 out of 20,000 on the market. Those are subject to highly specialized rules, and we think it fits within this court and Supreme Court precedent regarding field preemption. But if you were not to go that far, you would still find, we believe, conflict preemption principles to apply because the balance and the factors that the FDA considered override.
I want to come back because the concern I have is the genesis of your argument, of your preemption argument, is that the FDA has, pursuant to its REMS protocol, set down a set of conditions for the use of a particular drug. But if we think that that sort of REMS regulation, all of which is likely to be somewhat detailed, is preemptive, doesn't that cut the states out of the picture almost completely? And doesn't that use it says that I thought that the REMS protocols were meant to be a floor and not a ceiling. And have you cut the states out of the picture to the extent that the states are no longer able to pass additional safety regulations in furtherance of the safety and health of their own citizens? Doesn't your view of preemption preclude the states with a wide variety of drugs, not just this one, but a wide variety of drugs? Doesn't it preclude the states from adding additional safety measures on top of the REMS to further the health and safety of their own citizens? I mean, I think the theory that's propounded here could potentially put the states in handcuffs as far as health and safety of their citizens is concerned. Is there something unique about this REMS that doesn't apply to any other REMS?
Well, there are only a handful of drugs that are subject to these specialized rules, Judge Wilkinson, and I do want to emphasize this point, which is crucial. The other side has no case or history of any state at any time restricting access to an FDA-approved medication. None. You can ask, there is no case on this. The only case, Massachusetts tried to do this once, was held preempted by the district court, no appeal taken. And so against a history where FDA has had superintendents over medications, when Congress says under this 2007 law, we need you to impose additional rules that will ensure access with balancing safety interests that affect the healthcare delivery system and rural areas and special needs patients.
As a follow-up to Judge Wilkinson's question, isn't the issue of safety, health, and medicine a field traditionally left to the states?
Not in all circumstances. So, for instance, in the Arizona case, the Supreme Court held that safety restrictions that affected unauthorized, undocumented persons from working were not subject to state rules. In Gade, the Supreme Court held that specialized rules regarding hazardous material workers were subject to a limited subfield preemption theory, if you will. So just calling something safety or health is not ever been deemed to be exclusive.
What are you saying to me? Are you saying that the interest in the welfare of an unborn child is not a safety interest or a health interest that the states can assert pursuant to their traditional police powers?
What I'm saying is that Congress...
No, answer my question.
I think the answer is no. Congress entrusted the balancing on these factors to the FDA. So the FDA set forth rules that said that this drug can only be taken within the first 10 weeks of a gestational period of an embryo.
If Congress entrusted the balancing to the FDA, what about the savings clause here? It's been very unusual that we would find a statute to be preemptive with a savings clause, and it appears to be a pretty not a weak savings clause, but it seems a strong saving clause. It says there would be nothing in the amendments made by this act shall be construed as invalidating in provisions of state law, which would be valid in the absence of such amendments, unless there is a direct and positive conflict. I've read savings clauses, and, in the whole gallery of savings clauses, this seems to be a pretty strong expression. And in the face of that, are we to find that there is, that Congress intended to preempt? Because when Congress intends to preempt, it doesn't enact that kind of safety clause.
The answer is yes, Your Honor. The 1962 Savings Clause only applied to the 1962 Act by the plain language of the Savings Clause. Number two, Congress could have enacted a Savings Clause in the 2007 Act. It didn't do so. The 2007 Act imposes many more restrictions and powers on the FDA over post-marketing surveillance than the 1962 Act. And the Supreme Court in the Locke case took a savings clause that had been enacted in the Oil Pollution Act and said it didn't apply, even though that act was a subset of the Port and Waterway Safety Act, where the court found both field and conflict preemption.
To be honest with you, some of the Supreme Court cases point in different directions.
Well, and I appreciate that, and that's why we have argued both field and conflict preemption, because the line is sometimes a little bit fuzzy between which applies. But what is very clear is that for cases like this one, where the state is interfering with the judgments made by the federal government, there is at least obstacle preemption.
So one thing that occurs to me, because I'm a member of an inferior federal court, and I don't, what I think of the law or what I don't think of the law is totally unimportant. It's not relevant whether I like it or whether I don't. But what is relevant to me is that I want to do my best to follow the decisions of the Supreme Court. And you have the recent Dobbs case, which engenders very heartfelt reactions on both sides. But the gravamen of Dobbs was that a question such as this should be left to the states. And how do we square up with the Supreme Court if closely on the heels of Dobbs we say no, we're taking it entirely away from the states and making it completely a federal issue. And so I really worry about just a kind of being in a sort of a semi-rogue position vis-a-vis the Supreme Court. Do you see my concern?
Absolutely, Judge Wilkinson. Let me try to reassure you, and if I could take a moment to make a couple of points that are along this line. Number one, Dobbs, in its footnote, said the issue should be returned to, quote, elected representatives. Elected representatives in Congress enacted the 2007 Act. Number two, Dobbs concerned an individual right. Our case concerns an FDA-approved medication where there is a clash between the balancing that the states are seeking to impose and what the federal government chose to impose. That is a classic preemption question.
What if the inverse were true? Well, let's take a look at the inverse. And when I say the inverse, suppose there was a drug that the federal government tried to regulate for whatever reason. And let's assume that in West Virginia, I'm going to use that as an example, this drug was proven to be very, very good for people who suffer from black lung disease, which is prevalent in West Virginia. And the legislature in West Virginia said, even though we are concerned about the federal mandates and the suggestions of the federal scheme, because this is good for our citizenry, because we have a high level of these types of situations, we're going to make this type of drug available for our citizens. What would be wrong with that?
Well, if there was no action by the federal government, there would be...
There was assuming that the federal government had some restrictions on the use of this drug.
Well, the restrictions have to dovetail with what the state is seeking to do. That is the Supremacy Clause question. Is there a clash, an impact between what the states are requiring and what the federal government has set forth? And so, Judge Alston, I can't answer your question entirely satisfactorily because it involves a lot of facts. But let's suppose that we understood a federal regime and the specific rules that it imposed for this black lung drug. The way you would analyze that question is you would compare what is the state's regulations or rules and permission structure, and does that clash with what the federal government is saying? So the fact that it is inverse, where the state is being more permissive than the federal government, may or may not lead to a conflict preemption problem. And whether or not there's a field preemption problem would depend on whether this black lung drug was subject to the specialized rules under the REMS with safe use elements. And so absent knowing more about the facts there, I can concede that there might be some circumstances in which this black lung drug would be perfectly acceptable, but for the existence of federal rules on that particular topic. I see that my time has expired, but I also see that you have a lot of questions, and I'm happy to answer your questions, Your Honors.
First of all, I think I've taken up your time, a good bit of it, and so I'm going to give you some extra time because you deserve that. And I also want to make sure that my fine colleague here has a chance to ask you questions.
I do have a question about the restrictions from West Virginia. The counseling restriction, which is definitely in conflict with what the FDA has said regarding whether it's one pill or two pills, and you can start and then you can stop. I mean, isn't that exactly what Congress does not want to happen under this uniformity of regulation of this drug?
Correct. That is absolutely the fact that those are conflict preempted by the FDA's contrary judgments. Now, those rules are not part of the UCPA, so only if you were to find that the restrictions by the UCPA run afoul of the Supremacy Clause would you then consider the counseling, the informed consent, those provisions which are at the back of our argument, but which we did challenge in the district court as inconsistent with normal conflict preemption principles. I want to point out that one of the other features of this is that Congress enforced a periodic evaluation process on the FDA to ensure that the rules that was enacting for these REMS with safe use elements would be periodically evaluated. If the other side's position is correct, every state and territory and the District of Columbia could enact its own regime, it would be impossible for the FDA to do the periodic evaluation that Congress mandated in 355.1. And I also want to point out that it is a truism here in this statute that what Congress told the FDA was to take into account the health care delivery system. So when cities like Baltimore talk about all the West Virginians that have to come to get health care in Baltimore, that is exactly the kind of problem that Congress entrusted the FDA to determine so that there would be appropriate access to this medication, balancing the effects on rural areas and the healthcare delivery system.
Follow up on Judge Benjamin's question, you only get there if the preemption issue is decided in your favor.
As to the overall restriction, that is correct. If you conclude with us that the restrictions on the medical emergencies and the non-viable embryos are inconsistent with the federal scheme, then you would then approach the other provisions that preceded the UCPA.
Wilkinson, can I ask one quick question on standing, because you haven't had a chance to address that?
Yes.
Give me your, I've read your brief, I understand your position on standing, but state in open court here what your basis is for standing, and we all know what the general principles are, economic or otherwise. Tell me your basis for suggesting that GenPro actually has standing in this case.
Well, we've sold 850,000 units as of the time we filed the complaint. That's paragraph 3. We allege that West Virginia constricts our ability to sell. That's complaint paragraph 74. We allege that mifepristone has increased sales over time. That's paragraph 76.
More of an anticipatory loss, I guess.
Well, and I represented, and this is at JA 127, that GenBioPro had sold mifepristone in West Virginia in the past. We don't read this court's cases. Maryland shall issue the Seventh Circuit case of Izell and the 10th Circuit case of 303 Creative as requiring past sales. And of course, if that were the rule, it would restrict any newcomer into a market from being able to have standing to challenge the illegality of a statute. But suffice it to say, we have alleged an economic injury and we have satisfied the requisites of third-party standing on behalf of the purchasers and users of our product to be able to challenge the unenforceability of the state statute here.
Thank you.
In your previous response to a question, you said you evinced a great concern that each state would enact its own regime. But isn't that part and parcel of what goes along with our federal system, that states can take a different approach to difficult questions in the interest of exercising its protection of their citizens? I mean, the fact that states may come up with different approaches, why isn't that something that's just inherent in the way that dual sovereignty is meant to operate?
Well, Judge, I will quote back to you your decision in the PPL Energy case where you said...
What?
Your decision in PPL Energy where your opinion for the court made clear that it is a question of congressional intent, and the congressional intent is the touchstone of every preemption question, which is why I started with the text of the 2007 Act, and we put it in our addendum to our brief.
Well, I started with the text with the savings clause, and I want to ask you another question about congressional intent, which you are absolutely right to say is important here. I think that the Supreme Court is putting an emphasis on clarity in the expression of all law, whether it be Congress or whether it be administrative regulations or whatever. And given the savings clause, it is more difficult for me to see a preemptive intention on the part of Congress. But given the fact that clarity is important, where in the statute or where in the regulations does Congress mandate access to this particular medication?
355-1F, I'll quote it. It says, providing safe access for patients to drugs with known serious risks that would otherwise be unavailable. The very provision under F, and this is at Addendum 12 to our brief, makes clear that what Congress was seeking to do was to have the FDA entrusted with balancing how much access with the restrictions that would affect the ability of a patient to have access to that particular drug. That is a question of...
I'm not sure that Congress was undertaking, number one, the question is whether that balance should be undertaken by Congress or the states. The question is, if there is a balance to be struck, did Dobbs intend for the states to be part of striking that balance?
Well, 2 points. Number one, the statute says the Secretary, and we're talking about the Secretary of Health and Human Services under F1. And number two, Dobbs, in revisiting Roe versus Wade was decided at a time when there was no FDA-approved medication to terminate a pregnancy. And so surgical abortion was the predominant, if not exclusive, means of terminating a pregnancy at the time of Roe. So when Dobbs is overruling Roe, it doesn't speak to the statutory question that we have raised here.
Why isn't the language that you read me and that you pointed to, do we need to interpret that as some mandate that access be afforded, or is it fair to say that the statutory language means when and if it's used, it should be used according to these safety conditions? But as a predicate of that, the safety conditions precede, move forward on the assumption that not that there's mandatory access, but that if access is achieved, here are the conditions. And isn't that all that Congress isn't that all that Congress is saying here? Not mandate access, but if access is afforded, here are the conditions.
No, what Congress is saying is that we're entrusting the Secretary through the FDA to make those determinations based on safety, science, access, effects on the healthcare delivery system, provision to people in rural areas. It is a classic balancing question, Judge Wilkinson, of the type your decisions for this court have rendered a number of times in finding preemption where the state is seeking to second guess what a federal agency is entrusted with Congress to decide. The state of Washington, for instance, in Locke, couldn't decide to allow higher restrictions on oil tankers coming into Puget Sound simply because of its deeply held belief that those were necessary to prevent an oil spill. The Supreme Court said that's preempted.
I'm a big fan of balancing, but doesn't this tip the balance dramatically against the states? And as I understand it, the presumption, if you take the Supreme Court's case law as a whole, the presumption is against preemption. There is a presumption against preemption because it would destroy the balance between the supremacy clause and dual sovereignty.
No, not where there is a federal activity that has been exclusively federal for over a century. The question about the presumption against preemption only applies when there is an historic practice of the states that is at issue. That's not true here. As I opened this argument, there is no case where a state has sought to limit or restrict an FDA-approved medication. There is no action by a state seeking to do that other than this kind of situation that we're talking about here. And so the presumption simply doesn't apply. And if you look at language in Locke and in Arizona versus United States, what the Supreme Court said was actually In those activities that have been exclusively federal, there is the opposite, which is that the presumption is that the federal government is supreme under the Supremacy Clause.
But if a state should decide in its wisdom that a drug which was subject to the REMIS protocols would still be substantially unsafe for its own citizens to use, isn't it a real invasion of the state's police power to say that a state has no authority whatsoever to restrict its citizens' use to a drug or medication that the federal government has already decided to be a sufficiently high-risk medication that required the REMS protocols?
No, that's actually an incorrect statement of the law, Judge Wilkinson, where Congress entrusted the Secretary with doing that kind of balancing, where an expert agency that's got scientists and doctors and all kinds of protocols for ensuring safety, mandating clinical trials, enrolling patients into post-marketing surveillance, all of these things are things that states never have done. Under those circumstances, Congress made the decision that we're going to have one uniform decision maker because we want to affect the healthcare delivery system as a whole.
So let's say we have a drug like OxyContin or some of the pharmaceuticals, some of the drugs that have been put out by our pharmaceutical companies. Some of them produce great benefits, okay? But they also, together with those benefits, they carry substantial risks. And suppose with respect to OxyContin or some federal drug, or it's not some federally approved drug under certain circumstances, a state said, yes, I understand that the federal government has approved this drug under certain set of circumstances, but the safety and welfare of our citizens require that additional precautions be taken because we've seen what, by dint of experience, the negative effects that OxyContin has, along with its positive benefits, and they're both. I would never say that something's wholly, unbeneficial or whatever, but wouldn't a state have the authority to add additional safety precautions to protect its citizens if they thought a particular pharmaceutical drug carried risks above and beyond what the federal government had decided, and even so, the federal government has not decided that this is happy-go-lucky kind of thing. The federal government has already made the decision that it is a medication of sufficiently high risk that a REMS protocol and conditions had to be imposed. And what I'm suggesting to you is that a state can look at it and say, look, we're hearing all kinds of reports in legislative hearings and elsewhere from people who have used these drugs, and they're too freely available, and we appreciate what the federal government has done, but we want to add additional safety precautions of our own. And to say that a state can't do this, doesn't that just doesn't that really substantially impair the place of the states in our federal system? That's all I'm asking you.
And I'm saying the answer is absolutely not. And if I could answer you in a couple of different ways, Judge, to reassure you. Number one, at the general level, that position is wrong because states do not have the kinds of monitoring, evaluation of clinical trials, all that kind of data that FDA takes in, and Congress knew that, and Congress has entrusted FDA with that decision. Number two, on OxyContin. OxyContin was regulated under the Controlled Substances Act long before the 2007 Act was implemented.
I was just using that illustratively.
I know, but I want to answer the question because I don't want you to leave this courtroom under any illusion that our position is anything but 100% correct. The Controlled Substances Act provided a dual sovereignty so that for those drugs that were subject to the CSA, there was a role for the states in working cooperatively with the federal government in some instances to apply more restrictive controls because of the addictive nature of drugs that were on the Controlled Substances Act various lists. And so I don't think, Judge Wilkinson, with respect to your questions about general principles, you cannot decide this preemption case on the basis of larger principles where you have a specific statute to implement.
This opioid crisis is ravaging the Ohio River Valley. It's ravaging upper New England. It is a brutal thing, and all I'm asking you is whether a state could not, in light of its experience, take some recognition of the risk of addiction, of a lifelong addiction.
Of course.
That would change somebody to this particular drug. And could not a state act to reduce or mitigate the risk of addiction by enacting some additional conditions on access?
Yes, under the Controlled Substances Act, there are provisions.
Can a state do that?
Yes, but the mifepristone is not subject to the Controlled Substances Act. It's not addictive. There is not a risk of an addiction or of a similar kind of crisis with opioids.
Oh, I'm speaking of risk generally.
I understand, but Judge, I think it's important to take into account that West Virginia here did not do some safety analysis of mifepristone before it enacted the UCPA. It enacted the UCPA without knowing what any of the science was.
What other drug has Congress exercised from the FDA, I guess, under RIMS? The same kind of oversight, because there's a comprehensive oversight here as to who can prescribe the drug, how you can prescribe the drug. I mean, where it appears that Congress is or the FDA is pretty descriptive in how this drug is supposed to be used, which is not under the traditional realm of the FDA.
We've given a few examples in our brief, and I struggle to pronounce them correctly. So for the drug makers out there listening, I apologize that I can't pronounce it, but we've talked about isotretinoin, which is a drug that is used in contraception circumstances. We've talked, you can look at clozapine, Caprelsa, ambrisentan, lenalidomide. There are roughly 70 of these drugs, and they have various restrictions on them for the circumstances. One drug, for instance, an acne medication, there's a REMS so that you don't take that when you're pregnant. And because of the consequences that could happen, that very limited category of potential users. And those restrictions are the ones that the FDA has imposed. But I want to point out that these REMS are different for the different drugs based on FDA's careful study of the science and the circumstances.
Which the states have not done.
Correct.
And that's why your argument is that there is this narrow group of drugs in which Congress has delegated to the FDA in terms of for safety reasons and access reasons.
Correct. And for those reasons, Your Honor, I think it's really important to approach the statute as a plain language textualist would, which is to understand what was Congress trying to get at in the 2007 Act. The other side doesn't really take issue with our interpretation of the statute. They want to argue the case at very large, broad principles without looking at congressional intent. But preemption is a question of congressional intent.
We thank you. We wanted to give you some extra time because
21 minutes.
we wanted to make sure you had a chance to get your case. Ms. Hawley, let's hear from you.
Judge Wilkinson, and may it please the court, my name is Erin Hawley, and I represent the state of West Virginia. According to Gen Biopro, the 2007 amendments to the FDA radically altered the federal-state balance long set by Congress for drug regulation.
You would agree that there's no savings clause in the 2007 amendments?
I would not agree, Your Honor. The court in Wyeth, as my esteemed counsel said in the Merck case, the court in Wyeth interpreted that clause broadly. What Congress was doing in 1962 was looking at the traditional trajectory of state and federal regulation. And as the court said in Wyeth, Congress since 1906 has always sought to preserve state authority. In enhancing authority in those 1962 amendments, Congress said, we want to make it crystal clear. We are not in any way intruding upon the state's traditional authority to regulate the practice of medicine. So that clause does apply to
It's not in the 2007 amendments.
No, but I believe it applies to it, Your Honor. So to continue, Gen Biopro says that the FDAAA sets a federal ceiling in addition to the traditional federal floor and boots states from their traditional prerogative to regulate the practice of medicine.
What kind of practice of medicine are you pointing to that the states have had traditional authority to regulate? What examples do you have?
Absolutely, Your Honor. I would point you to the case of West Virginia versus Dent, a case from the late 1800s in which the United States Supreme Court clarified way back in the day that states are entitled and have the authority to regulate medical licensure. That's just one example. Your Honor mentioned opioids.
But medical licensure is not medicine. You're saying, for your sake, citing a case from the 1800s that deals with, I would agree with you, the states have the authority to deal with whether a doctor has a license, whether a nurse has a license, but we're talking about the regulation of the medication here.
So, Your Honor, I would cite you to something called FDA Facts. It has public question and answer. And the question the FDA poses there is, does FDA regulate the practice of medicine? And the answer is no. The FDA has never taken the position that it regulates the practice of medicine. It also goes on to state that the FDA does not regulate accessibility of drugs. That is a traditional understanding of the FDCA. It's a traditional understanding of the Supreme Court. I would also point, Your Honor, to JA 87 and 88. At that page, we cite to the FDA's Q and answers regarding mifepristone. And what the FDA says to healthcare practitioners is, if you want to know whether you can prescribe this, quote, check your individual state laws. The FDA itself acknowledges what has always been true under the FDCA, and that is that states get to practice medicine. They get to regulate the healthcare field. They get to, as Judge Wilkinson was pointing out, set additional regulations on really high-risk drugs like opioids.
What if the state decided to, what if the FDA decided to regulate a cancer drug? By way of example, I asked your colleague a question using a hypothetical. Decided it wanted to regulate a cancer drug, and suppose that a state, I'm not going to pick on West Virginia, decided that it wanted to not allow this drug to be used because it used stem cells. Could a state do that?
So I think that's a more difficult question, Your Honor, but I do think it brings up something really important with respect to field preemption. So field preemption doesn't exist here for two reasons. One, as this court said in Johnson versus American Towers, where you have a savings clause, fundamentally, field preemption cannot exist. But second, and to your point, Judge Alston, that when Congress and the states regulate in separate fields, the Supreme Court has been clear that that's okay. So the case, and it controls this one, is called Virginia Uranium. And in that case, Virginia was regulating mining. The federal governments had exclusive comprehensive regulations of milling. And what the court held and what Justice Ginsburg said in her concurrence was that where a state is regulating an upstream activity, like West Virginia is doing with mifepristone, with abortion, then the fact that something, even if it were to fall into a federal enclave, which it doesn't here, then that would be different because they're different fields. So this case fails field preemption for several reasons. Again, there's a savings clause. In addition, they're regulating different fields. Gen Biopro is not even regulated by the UCPA.
Suppose the Congress were to say, to mandate access to this particular pill. You would have no problem with that if Congress were to mandate access, would you?
I don't believe so, Your Honor. That's absolutely not this case. But to be...
I'm asking you, does Congress have the power to mandate access to this particular pill and to preempt any state from restricting it if it wanted to? Because I'm interested in what the powers of Congress in this area are.
Sure. So, well, as Your Honor noted, Dobbs returned the power to regulate the matter of abortion to the states, to the elected representatives. So there might be an argument that Congress, if through its democratically enacted branches, set some limits on abortion, as they have in the Partial Birth Act, then that's permissible. I think it's a harder question whether Congress itself can regulate or require nationwide abortion access. Of course, in Bernie versus Flores, the Supreme Court said that the Section 14 powers, Section 5 powers can't go above and beyond the right recognized by Congress, or excuse me, yes, by the Supreme Court.
And what enumerated power it would link up to?
Yes, and under Bernie versus Flores, there must be an identified Supreme Court
But
right.
Did Congress come pretty close to mandating access when there's statutory language that says the conditions that are imposed pursuant to remedies shall not unduly inconvenience or burden any patient? I mean, what I'm asking is, even though Congress didn't flatly mandate access with the language that patient access and should not be unduly burdened or patients should not be, unduly burdened. Isn't that coming close to mandating access?
Not at all, Your Honor.
Why not?
And because let's look at the statutory text together. And my friend on the other side, he uses a lot of ellipses when he quotes West Virginia statutes as well as the FDCA here. And what it says is 355(1)(f)(2), and the district court was right to focus on this. And it says such elements to assure safe use under paragraph 1. So what Judge Chambers found correctly was this such elements to assure safe use under paragraph 1 is a clear indication that the only entity, the secretary, as my friend noted, the only entity that needs to consider access is the FDA. There is no indication anywhere in the FDAAA that Congress intended to displace states from their traditional authority. Again, to look back to the Wyeth case, Your Honor, the court found persuasive that Congress knows how to preempt state law when it wants to. It did so in the 1976 Medical Device Amendments, and it also did so in the FDAAA.
All right, but with respect to the conditions that were put on use, and with respect to the REMS protocols, didn't those proceed under a presumption? Maybe it's an implied presumption, but didn't those the safety use features proceed under at least an implied presumption that access to the medication or the pill would be provided?
I don't think so, Your Honor, because the status quo is that these drugs wouldn't be on the market. They're high risk. They are associated.
Why wouldn't it be, what would be the reasons to enact the safe use provisions unless there was a presupposition that access would be provided in order to use them? I mean, the safety use provisions assume that access would be provided, don't they?
No, Your Honor, and the reason being is that the FDCA writ large has never been interpreted to require access. It's never made Gen BioPro sell a single drug, much less at an affordable price. There is no emphasis on access. Rather, what Congress was doing with the FDAAA is making sure that really high-risk drugs were subject to sufficient protocols.
Would we be the first court? I'm always concerned about circuit conflicts. Would we be the first court in the United States to mandate access or to find that this statute mandated access to the extent of preempting states to limit it? Would we be the first court to do that?
Yes, you would, Your Honor. In fact, Gen BioPro originally filed suit in the Fifth Circuit, but voluntarily dismissed. So this court is the first court to consider this question.
Okay, so you're saying that there's no district court anywhere that has mandated access?
No, Your Honor, not under a statute like this. So Judge Chambers had it correct when he looked at Section 355(1). He said that was, quote, plainly directed only to the FDA.
Now, if we were to be the first court to take this step of mandating access, which you say is unprecedented, is that because other courts have rejected the idea of mandating access, or is it just because insufficient cases have been brought, and there have been scant, few, if any, rulings? Why would we be the first court to do this? Is it because there's a paucity of other cases out there, or because the courts that have taken up the question agree with your perspective?
So I think it's both, Your Honor, and with Judge Chambers' decision below agreeing with us. But I think there's a reason that there's a paucity of cases is precisely because no one, including the FDA, has ever thought that Congress in 2007 was mandating nationwide abortion access. Instead, the 2007 amendments, they were passed by a bipartisan Congress, unanimously waved through the Senate. All but a few House members voted for these 2007 amendments. And to get back to that keystone, that touchstone of congressional intent, one of the Supreme Court's key inquiries is the context of the statute and what else the statute says. Here, Your Honor, if I could point you to 121 Statute 922. This is in the FDAAA. It's 801D, and it's entitled Preemption. And what Congress does in this narrow provision is it preempts, it says no state shall enact any requirement on the registration of clinical trials. That's in the FDAAA. That shows that Congress plainly knows how to preempt state law when it wants to. It did not do so in this case.
So is your view that with highly controversial questions, which this one is, we would all agree, that requires a crystal clear expression of intent from the national legislative branch in order to displace state authority in the area?
I think that's correct, Your Honor. It's correct under the presumption against preemption because we are talking about traditional state regulating the medical health and safety field. It would be true under field preemption, which requires a clear and manifest intent from Congress to preempt a field. And it would be true
On some sort of sliding scale, and that the more controversial and volatile a question is, the clearer the expression from Congress must be?
So I don't think so, Your Honor. That there is the major questions doctrine, which I haven't talked on yet, and I think, or haven't touched on. I think Gen BioPro's view of the FDAAA would implicate the major questions doctrine. Counsel again was forthright.
With the comprehensive nature of the regulation, the way that the leave no room for the states. Directly or indirectly, because it's so comprehensive under this REMS, he says it's 70 drugs. I'm just trying to figure out how because as I asked him earlier about it's comprehensive. It tells you who can take it, how you take it, how the doctors are supposed to. More oversight than any other drug. Does that comprehensive nature leave no direct or indirect room for the states?
No, Your Honor, and I think GenBioPro vastly overstates what the REMS do. Its own amici have acknowledged that the REMS are limited and invited states to regulate alongside. If you look again at FDA's question and answers, it says it does not regulate the practice of medicine. It instructs the FDA's Q&A for mifepristone, instructs state healthcare providers to, quote, look to their individual state laws to see who may dispense the drug. It's simply not correct that the FDAAA regulates drugs like opioids, like mifepristone end to end. Congress has never asserted that sort of authority over the practice of medicine, and that would require some sort of clear statement, some congressional intent in the statute. But instead, we agree with Judge Chambers that every indication is that Congress meant to save state laws, like the UCP at issue here. He said that Section 355(1) was, quote, plainly directed only to the FDA and not didn't boot states from their traditional authority. I also wanted to take just a...
What if a state did something that was absolutely incongruent with the FDAA mandate? What would be your suggestion there?
So in that perspective, Your Honor, I think we would be dealing with purposes and objectives preemption. Field preemption doesn't exist. It could be a case of impossibility preemption. With impossibility preemption, it's a demanding standard. It says that in a federal law might require something and a state law might forbid it. So if that was your hypothetical, then that would be preempted by impossibility preemption. The third bucket of preemption cases are those involving sort of purposes and objectives preemption. Now that, of course, is the bucket of preemption that the Supreme Court has been cautious about.
So there is preemption here to an extent. In other words, I guess I'm just trying to figure out the position is that the states are free to add additional protections, but the states are not free to subtract. I mean, if suppose a state wanted to say that the REMS safety protocols, for example, are no longer operative, or such and such and such and such of the REMS safety protocols, this certification is no longer operative. And they were subtracting from the safeguards that Congress provided, that would be preempted, would it not? Subtraction?
Absolutely right, Your Honor. Under obstacle preemption, that would be contrary to the purpose of Congress to make sure that these high-risk drugs are safe.
So we are talking about, we're not depriving, your position is you're not depriving the statute of preemptive effect. You're simply saying that the statute does have preemptive effect in the sense that the states cannot relax or discard the federal conditions, but that the states can add additional safety measures. So it's sort of a question of floor and ceiling, isn't it?
Absolutely, Your Honor. So if a state tried to take away one of those crucial safeguards for a drug, that would run directly into obstacle preemption, and that the FDCA's mandate to ensure that these drugs are safe. So you could have impossibility preemption, you could have obstacle preemption in those sorts of circumstances.
Why would Congress and why would the FDA go into all of this detail, all of this voluminous detail, if it did not intend to preempt? I mean, this is not something that they just sort of waved a wand over it. They looked at this issue, they addressed it in the most meticulous way possible. So why isn't that an important indicia of congressional intent?
So I think that would go to the field preemption bucket, which I think doesn't work because of the savings clause and because they don't regulate the same fields. But even putting those aside, Your Honor, that there's not, the reason there is detail in this statute is because Congress and the FDA are dealing with the most dangerous, the highest risk drugs on the market, which are associated with severe adverse, or serious is the statutory language, adverse consequences. So FDA is taking precautions, post-marketing precautions to ensure the safety of individuals who use those.
So you're saying that the scheme you're proposing preserves rather than eviscerates an important role for the FDA?
Absolutely, Your Honor. The role of the FDA here is to make sure that the drugs it approves.
You're saying, and just to make your position, to make sure I understand what the respective positions are, you're not seeking to put the FDA out of business.
Not at all, Your Honor. We are thankful.
This is not a full-scale assault on the administrative state or anything like it. It's, say, the FDA retains an important role, and the states are not free to relax the safety protocols that the FDA has implemented.
That's absolutely correct, Your Honor. And that's been the FDCA, Congress's intent in the FDCA since 1906, that states come along and supplement. They add to, but don't take away from those federal protections. And I wanted to take just a minute to talk about the sort of odd statute that would exist if GenBioPro were correct. So as Your Honors have noted, things like opioids, that there's no way to distinguish opioids from mifepristone. The fact that another statute, the Controlled Substance Act, also governs opioids isn't a reason to say that a separate statute, the FDAAA, doesn't have the effect GenBioPro says it otherwise does. So opioids are subject to the same restrictions as mifepristone. If mifepristone can't have additional safeguards, then neither can opioids. The second oddity with GenBioPro's position, Your Honor, is brought to light by the Supreme Court's decision in Wyeth. And there, my esteemed counsel on the other side persuaded the Supreme Court that one reason that state regulation was important was because the FDCA doesn't have remedies. That means if an individual is injured by an unsafe drug, there's nothing they can do under the FDCA. Instead, according to Wyeth, what Congress determined was that state tort law would come alongside and support and provide that cause of action. Under Bartlett, this is at 491, there's no distinction for preemption purposes between common law causes of action and state regulation. That's been true since Judge Calabrese's, Windows from the Cathedral. Both impose duties and obligations, and there's no way to carve out common law causes of action. And then third and finally, Your Honor, is that in the Eastern District of West Virginia, 12 attorney generals have sued FDA, saying that the mifepristone rims are too intense, that they should just be taken away, that the drug is super safe, despite the FDA's own label. Now, if that were to happen, if the court or the FDA were someday to withdraw its RIMS restrictions, under GenBioPro's view that these RIMS are different, then state laws protecting life would suddenly spring back into being. That can't possibly be what Congress intended in 2007.
Let me ask my colleagues if they have further questions of you. Judge Benjamin, do you have some further questions?
Yes, sir.
We thank you very much.
Thank you, Your Honor.
Mr. Frederick, you have some rebuttal time.
Thank you, Your Honors. I want to start with the idea that the FDAA supposedly erases states' police power. It does not. What it says is that the states have a role with respect to the subject matter of unborn life, but they can only exercise it outside the idea of where the FDA has given that power to the federal agency. So surgical abortion, our case is not about that. Our case is not about mifepristone outside the 10 weeks specifically prescribed by the FDA for its safe use. And so to go beyond that and assert that our argument is broader than that is not correct. Judge Wilkinson, you asked whether this would be the first case to uphold access. You also, if you were to rule on their side, be the first case in the history of the United States, the first court of appeals, to hold that a state can restrict access to an FDA-approved drug, and not just an FDA REMS drug, but an FDA drug of any kind. No court has upheld a state restriction of the type that West Virginia is asserting here. There is no safety rationale behind the UCPA.
Don't we really get down to how Dobbs sort of affects this whole inquiry? Because, you know, whether you agree with it or not, the bottom line is that the Supreme Court seems to suggest generally that these types of questions on abortion, and that gets people all fired up about it either way, and that's understandable, should be best left to the states. And because we live in the United States of America, if you want to access certain things, you can move to a state that allows it. If you don't want to have access, you live in a state that doesn't. In other words, it allows individuals, the citizenry, to make their determinations based upon what is best for them.
With respect to surgical abortions, I agree with you. With respect to medication abortions, Congress disagrees with you, because Congress enacted a comprehensive scheme in the 2007 Act to ensure that the FDA would balance access to a drug with all the other restrictions that would be necessary, while keeping in mind rural areas, regardless of what state, the healthcare delivery system, regardless of what state, the procurement of drugs, and the national delivery system with respect to medical devices and issues without regard to states. And so Dobbs addressed the question of the individual constitutional right. It did not address the statutory question we have presented here, which is whether Congress has an intent to preempt an effort to encroach on either the subfield of these REMS drugs with safe use elements, or to conflict with the decisions that Congress has made. Now, the other side boils its argument down to this proposition: Congress did not mandate access. What Congress did was that it entrusted the FDA to balance allowing and providing access with these other safe use elements. And so they don't question that their position actually second guesses
I'm gonna
that.
ask you the same question that I asked your opponent colleague, and that is, could the FDA decide that it wanted to prescribe the use of stem cells? Suppose we had a conservative Congress and a conservative FDA, and they made that determination. Could they do that?
Well, I don't think that the question of how research is done for drugs is actually directly regulated under the FDAA. And so the question, the way you would answer the question, Judge Olson, and I don't have a clear answer for you that would be satisfactory,
And I appreciate that.
is that clinical trial research and the research that goes into drugs is often done at universities or at pharma labs, and they come up with their own protocols for designing the drugs and using the available materials for them in constructing those drugs. How that is regulated is not an area that I have expertise or knowledge about, but what I would say is that you would look at those scientific protocols that are done like under National Science Foundation grants, authorities under National Institutes of Health, et cetera, and you would evaluate the conflict preemption question the very same way we're doing here. What did Congress say, and how is that dovetail with what a state might seek to do? And you analyze that preemption question always on the basis of congressional intent. And so when the other side says that there is an opportunity for states to go beyond what the FDA has done, no, 355-1D provides a mechanism for interested people to petition FDA and say, we want the federal standard to be more strict, or we want it to be looser. And the states can do that, citizens can do that, interested parties can do that, and that is how this is traditionally done and regulated, and Congress provided for that. But then when Congress said we want the secretary to make the decision, it prescribed that in 355-1. And I note that my friend on the other side has not defended the proposition that her position leads to 51 different regimes, I'm counting the 50 states in the District of Columbia, And Puerto Rico, call it 52, call Guam, whatever. What I'm saying is that when Congress said for the FDA to enact a system for the healthcare delivery system, it was intending to create uniformity. And under classic obstacle preemption principles, the West Virginia statute leads to an obstacle preemption nightmare for an FDA that is entrusted with implementing and promulgating this statute.
All right, thank you, Mr. Frederick. We appreciate it.
Thank you, Your Honors.
Ms. Hawley, we appreciate it. We thank you both for your arguments, and we will adjourn court and come down and greet counsel.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.
We should just have a